Mixed reactions have trailed the recent Supreme Court judgment on the case between the Asset Management Corporation of Nigeria and Bi-Courtney Nigeria. To get a better understanding of the intricacies of this case, Evans Ufeli, a constitutional lawyer and rights advocate, now joins me for this discussion. Evans, glad to have you on the show this morning.
Thank you very much.
So over the last 48 hours, the media has been awash with different sides to the Bi-Courtney, FA and Amcon situation. There's been accusations and counter-accusations of misreporting, undetailed reporting. So help us understand what is the real story.
Well, it is important to outline the fact that the substantive suit in this case is between Bi-Courtney and FAN, that is FAAN.
The Federal Airport Authority of Nigeria.
Federal Airport Authority / the federal government. Okay, that's a substantive suit. In 2012, okay, the Federal High Court gave a judgment that followed with an order that the FAN, the federal government, pay 132 billion naira plus to Bi-Courtney, okay, which is an aviation servicing firm. Okay, and then when that judgment was given, or the order as it were, parties in the suit were dissatisfied, okay, and of course, the case went on appeal to the Court of Appeal. So at the Court of Appeal, of course, you know that Amcon is an interested party in the suit because Bi-Courtney is a creation of bond, which is a public interest investment. You understand? So while the case was at the Court of Appeal, okay, the FAN and the federal government had not offset the 132 billion, which is the order of the court. Now, Amcon now initiated interest to appeal that order as an interested party. You understand? So what happened thereafter was that instead of Amcon to seek a leave of the Federal High Court, because you have to seek a leave of the court of first instance if you are appealing, Amcon went to seek the leave of the Court of Appeal. That
exactly. The next point of is it conversation and this next point of argument for those in the media who have been trying to dissect the situation over the past 48 hours. Is there a case of jurisdiction in this matter? You highlighted earlier they started in 2012, there was a case before the Federal High Court, and one of the points of controversy in this matter now has been the fact that they went straight to the Supreme Court. Well,
the question is this: the Federal High Court had given a judgment and followed by an order. Okay, so the case have left the Federal High Court now to the Court of Appeal. Now, at the Court of Appeal, what is required if you have to, bring an appeal, you must go to the Court of First Instance, okay, to sought the leave of that court before you appeal to wherever. You understand? That was not
first instance in this case would be?
Yes, that was not done. Then what do you call it? Amcon went to the court, that is the Court of Appeal, to seek the leave to appeal to the Supreme Court. So what you now have that, what happened thereafter is that the Supreme Court now did not look at the substance of the matter. It only looked at the technicalities, okay, that Amcon did not do what it ought to have done.
Due process.
Yes, did not follow due process, okay? And as a result of that, it overruled or turned down the appeal, okay? And as a result of that, the media went about reporting that Amcon will have to forfeit 132 billion to, Bi-Courtney, and that is not the case.
So what for you would constitute the substance of the matter itself?
You
highlighted the due process flaw that they are being embattled in. Now, what would constitute the substance of the matter in question?
What constitutes the substance of the matter is between the federal government, FAN, and Bi-Courtney, which is the subject of offsetting the said amount, which is a process and order of court, and which has not been obeyed, okay, as it were. We should know that Amcon is not a party to the suit per se. Amcon is an interested, Asset Management Corporation of Nigeria. What they do is that anywhere you have public funds, any investment where you have public funds, in order to secure whether you have bonds, whether you have equity, you have all that. In order to secure that investment, Amcon is usually interested where there is a dispute or where the company is about to collapse.
So our investments in question here, our business is about to collapse in this case, because I've seen Amcon come out to say that the case, like you said, is explicitly between Bi-Courtney and the federal government of Nigeria.
Yeah,
so what will constitute Amcon's interest in this case?
Amcon's interest in the case is that they allege that Bi-Courtney is indebted to them to the tune of 119 billion. Okay? And then the Bi-Courtney itself said the federal government, the court gave an order that from the 132 billion, which, because Amcon is an agency of the federal government is the principal of Amcon, okay? And then the fact here is that they were asked to offset the 132 billion from the 119 billion. That, what I mean is that the court made an order that if Amcon claimed that Bi-Courtney is owing 119 billion, and then there is a judgment against the federal government for which federal government have to pay Bi-Courtney 132 billion. So there should be an offset, yes.
Subtract and pay the balance.
Subtract and pay the balance. Then what Bi-Courtney is saying is that it is surprised that Amcon is still, telling the federal government that they have 119 billion somewhere with Bi-Courtney, whereas there's a subsisting court judgment which has even ordered that there should be an offset, okay, so that you have a balance. And then Bi-Courtney is saying that there is no debt anywhere that exists in the process, because the court said that from that money they should offset all the agencies of federal government, including Amcon, was mentioned in the order of court, okay? So as it stands now, Bi-Courtney believes that there's no debt whatsoever, while Amcon keeps arguing that
there is a debt to be offset.
But now we have gotten to the Supreme Court, and since the Supreme Court have overturned it, it means that that argument has failed in all the courts in the land.
So could due process invalidate the argument that appears to now be in favor of Bi-Courtney?
Could
due process, remember we talked about due process before, scaling the federal high court and then going straight to the Supreme Court. Could that factor be a flaw in what appears to be the debt or non-debt argument between Bi-Courtney and Amcon in this case now?
Well, the fact is that there was no scaling. There was no scaling because the Court of Appeal determined the matter. You cannot appeal from the Federal High Court to the Supreme Court. The Court of Appeal determined the matter, okay? And then parties were dissatisfied and it went to the Supreme Court. It was not as if the Court of Appeal did not determine the matter. It was determined by the Court of Appeal. And then they went further. You understand? So the crux of the matter now is that the position of the Court of First Instance, which is the Federal High Court, have been upheld by the superior courts. So now the question is that Amcon must have to go by the description of that order.
Simply put, subtract what you consider debt and then pay the balance.
Yes, 132 billion, take 119 off it.
From 132
yes,
billion.
And then use others to use the other fund to settle all other federal government agencies.
Including Amcon.
Including Amcon in the order. So that is just the crux. But when you get to the media, we saw a different narrative that Amcon will forfeit this to and all that.
One of the narratives that did go out that Bi-Courtney had to release a statement to counter, maybe invalidate, was the issue of the tenure of the concession of the MMA2. I don't know if you're aware of that.
Yes.
It was in question whether or not they had a 36-year valid concession. There were reports that it was 12 years and it was about to expire. They had to let it go.
Yeah, I know about the fact that there is a contention as regards the concessioning, as regards the wordings of the contractual terms, which happens to be the substantive suit, okay, and then which the court is looking into, and then determining because the case is still at the Court of Appeal, the substantive suit. What was determined is just that part.
The money matter.
Yes, the money angle to it. The substantive suit is what you just talked about, which is sub judice. It's still before the Court of Appeal. And we'll definitely get to the Supreme Court as well. But for now, the parties must maintain the status quo and abide, having exhausted the options of appeal. As regarding that order of court, parties will have to obey that, and then the substantive suit will take off from the Court of Appeal, and then possibly if parties are still dissatisfied, they will go to the Supreme Court. And the Supreme Court will now determine the issue of the concessioning and every other ancillary matters within the prayers of parties in the suit.
And those will be the substantive issues before the court. Thank you very much for helping us set the record straight regarding the issues in court on Bi-Courtney, the federal government, and the Federal Airport Authority of Nigeria. Thank you for your time on the show. Evans Ufeli is a constitutional lawyer and rights advocate.